Hello, Zimbabwe, and welcome to our first episode of our program known as Know Your Constitution. This is a program being brought to you by Junior Court Council as its mandate to ensure that there is creation and increase of constitutional awareness amongst the youth of Zimbabwe. So today I am going to be hosting our guest here, Mr. George. Please briefly introduce yourself.
Hello, Zimbabwe. My name is George Agwesha. I'm a law student at the University of Zimbabwe. I'm now doing my part final. I'm also an executive member of the Junior Court Council, and also I'm the outgoing president of Zimbabwe Law Student Association.
Interesting. Thank you very much, Mr. Chagwisha. So I understand today we are going to be looking at Section 86 of the Constitution, which is the limitation clause. So briefly, how would you interpret what are the contents of Section 86 of the Constitution?
Okay. Thank you very much, Madam Bridget. I think the first point is to have a better understanding of what is exactly the Constitution of Zimbabwe.
Okay.
So the Constitution of Zimbabwe is our supreme law of the land, that is according to 2 of the Constitution, which means that it's above any other law. Okay, so if you check the Constitution, you'll find that between Section 44 and the Section 86 lies our important or sacred clauses or provisions. That is the Bill of Rights, Chapter 4, the Bill of Rights. So you'll find that from Section 44 up to Section 86, there lies the Bill of Rights. But the Bill of Rights, it did provide a list of rights and, of course, the limitations. The limitations are provided on Section 86 of the Constitution. So you'll find that our Section 86 is the limitation clause.
Okay, so what exactly do we mean when we are saying, Kuti, we have limitations to our constitutional rights? Our understanding would be that the rights that are enshrined under the Bill of Rights are supposed to be afforded to us no matter what. So what exactly is meant by the limitations?
Okay. The limitation clause can be traced back to the formation or to the history of the formation of a state and law. That is, according to the social contract theory on the formation of a state and law, you will find that before the formation of state and law, there was what we call a state of nature, where people used to enjoy their rights without any limitation. But can you imagine just enjoying the right of liberty without any limitation? For example, we can make a declaration, let's say just in H-Town in Harare, that we are declaring that you can enjoy your right of liberty without any limitation. You will find that if you are to enjoy your rights without limitations, you will be violating the rights of others. So the limitation clause is premised on that fact that if we are to allow people to enjoy their rights right now without any limitations, they will infringe on the rights of others. For example, just walk. You can claim that I have a right to liberty. Just walk and walk and walk and walk, but we end up maybe trespassing in another person's property, which is a violation of that person's right to property. So you find that there is a serious need for limitation. So from the premise of the social contract theory, you will find that after a chaos in the state of nature, because the rights were not limited, after that chaos in the state of nature, the people decided that we should limit our rights and surrender some parts of our rights to certain bodies, like the legislature, like the executive, like the judiciary. Because back then, people used to be judges of their own. People used to be lawmakers. People used to be law enforcers. But you find that the way people were enforcing, because there were no limitations, it ended up people enforcing their rights in an arbitrary manner, to the extent that there was a need for limitation. And people come to a consensus that we need to limit these rights. And
Okay, so it is our understanding, according to what Mr. Chagwesha is saying, that this is to ensure that when you are exercising your rights, you do not infringe upon another person's rights, and hence a limitation to your own rights. But then my next question is, I understand that the limitation clause leaves certain rights to say that these are not anyhow limited; they are absolute rights. Could you please shed more light on those rights that are then said not to be limited but are absolute?
Um, I don't think so. We have absolute rights, totally absolute rights. Because if you are to check the way Section 86, particular Section 3, was crafted, it was crafted in a way which leaves room. It uses the language may. They may be absolute. So you'll find that they can't be absolute. They may be absolute. And of course, it is us, the people of Zimbabwe, who did agree that these rights, they may be absolute.
Okay, so does that mean, on the basis of Section 3, as you said, does it mean to say that the right to life, the right to dignity, I understand those are the two that are closest to being absolute. Are you saying that there are also limitations to those rights?
Yes, there are limitations. If you check Section 86, subsection 3, it did highlight that the right to life is limited. That's why we still have the punishment of death sentence. It's a limitation to right to life. So it can be limited.
Okay, then I would want to understand to what extent are they limited, and these limitations, how exactly are they enforced upon a person, especially when looking at the very most important rights, such as the right to life and the right to dignity? How exactly will the state or any power which has that power limit those rights?
Okay. So you find that the good thing about our constitution is that it provides everything. If we are to read down along Section 83, you find it provides a yardstick for limitations. It says the limitation should be reasonable. It should be reasonable and acceptable in a democratic society. Okay, so you find that the yardstick is already there. As long as it is reasonable, it's fine. It can be limited.
Okay, there you have it. The limitation clause is saying that, of course, there are some rights that may be given some extent of recognition, but however, they are also limited by the state on the grounds that it is reasonable. Now, just as a quick, who measures reasonableness? How is this test of ensuring that this is reasonable? How do you assure that?
Okay, so you find that the question of reasonableness now it's difficult to assess, because if you are to check even the Oxford Dictionary itself, it didn't define exactly what is meant by reasonableness. Okay, but you find that it says reasonableness depends on the circumstances on the ground. So it's on a case-to-case basis. It depends with the case. What may be reasonable in this case, it may not be reasonable in another case.
Yes, clearly, what may be reasonable to one reasonable person may not be reasonable to another person. Now, as a legal scholar yourself, what are your personal opinions on the insertion of the limitation clause in the Constitution? Because for someone like me, this seems like, okay, so why are you giving us rights and then taking them at the same time? Because clearly you are saying I have got a right to privacy, but then you are also telling me that it's not absolute. You may infringe upon my privacy. So, as a legal scholar, what's your personal opinion around this whole thing of having a limitation clause in the Constitution?
First and foremost, I would like to highlight that it is the people of Zimbabwe who voted for the limitations. Because if you have to check our constitution, it says at the preamble, we, the people of Zimbabwe. So we are the ones who voted for these limitations. And of course, from legal point of view, the limitations are necessary. They are very necessary. Because once we allow people to walk scot-free, you'll find that they will infringe and violate other people's rights. So we want to make sure that these, in as much as we are exercising our rights as citizens of Zimbabwe, make sure that the rights are not violating the other people's rights. We are enjoying your rights in a manner that does not violate the other people's rights.
Okay, well said there. I would also pose the question that, so why is it important to the youth of Zimbabwe to know that when they're exercising their rights as enshrined under the Bill of Rights in the Constitution, Chapter 4, they should take recognition of the limitation clause? Why should it be important to me as a young person?
Okay, so you find that the major challenge we are having right now is that if people are just claiming that they have rights, the rights they do not understand. Where are they coming from? And I would like to thank the ministry. If you check the Ministry of Justice, it do provide for the constitutions in also vernacular language, in Shona and in Ndebele. It's a great initiative for the youths, because we cannot just go and claim our rights we do not understand. We have to understand rights first. So as youths, they have to understand rights first. Then after understanding the rights, then claim. And we have to read chapter 4 as a whole and in its context. So you cannot just claim that I have a right, I have a right, and without taking note of section 86. Because you may find it difficult to enjoy your right. Because you can say, I'm enjoying your right, while we are violating the right of others. And you find yourself being questioned and also taken by the law enforcement agents.
Okay, thank you very much, Mr. Chagwesha, for that very enlightening discussion on Section 86 of our Constitution, which is the limitation clause. And there you have it for our first episode. My name is Bridget T. Mambondiani. Thank you.